guys, Rogue Nation here with you today. And we got something a little bit different today. We're going to be going over some laws. We're going to be going over some fallacies that the other side has against what we do and their understanding of what we do and what we say and such like that. This is going to help everybody out there hopefully understand what we're doing a little bit better. Now, I'm going to pause this and talk about this video as we go along. They're discussing case law. As it says here in their description, case law proves frauditors are wrong. So we're gonna pause and we're gonna go over what they're saying here and there. So, all right, guys.
So, what specific cases did you want to talk about?
Yeah, and I want to. There's a long list, and I'll email everything to you as well. But first and foremost, all the auditors, they love to say the Constitution, the Constitution. They claim they live and breathe by the Constitution. Well, something very, very important that every one of them misses is Article 3, Section 2, which gives unilateral powers to the judiciary to interpret the Constitution. So basically what that means is if you have a disagreement, the courts decide who is right, the courts decide how the law is interpreted, and the courts decide how the Constitution is interpreted.
So right away, the idiot starts off talking about how we don't understand this. And I don't know anybody that doesn't understand this concept that the courts are the final answer when it comes to law, the interpretation of the laws, the application of the laws. Yes, everybody understands the judiciary has the control over that.
Extremely important to remember, because
let me just pull it up. So we're on the same page here. So you said Article 3?
Yep, Article 3, Section 2
of the Constitution. Okay.
Yep, go ahead, pull it up.
Okay.
Try to see if I can blow this up. Look at it.
Yeah, I can zoom in a bit.
Yeah, I can see it. Yep.
Okay, so
Article
3
up. Keep scrolling. Article 3. Yep, down. So this just basically talks about the judicial power extends to all cases, law and equity, rising on the Constitution. Controversies to which the United States, between two or more states, between a state and a citizen, between two citizens. So basically any controversy, the judiciary has unilateral powers to, in a nutshell, to determine who's right, to determine how the law is to be interpreted. And as such, it is the judiciary who interprets the First Amendment. Period. Full stop. That's how the U.S. Constitution. I'm sure you're familiar with the three branches of government.
Yeah.
The legislative, they pass the laws. The judiciary interprets. The executive enforces. So,
right.
The judiciary interprets everything. So that's why, and the reason I wanted to preface all what I'm going to share with you with this is that I guarantee you, this kid is going to say, well, the judge is wrong. Well, the judge is corrupt, or the judge is this, or the judge is that. Well, whoa, hang on for a minute. First, you said you believe in the Constitution, which gives the judge the power to interpret that. Now you're saying the judge is wrong. So are you saying you don't believe in the Constitution?
You see, that's a fallacy right there. So because we think the judge might be corrupt, because we think the judge might not know the law in this specific instance, supposedly we now don't believe in the Constitution because the Constitution gave the judge the powers to do that. So right off the bat, he's using fallacies. So we could see right there that he's wrong as far as that instance is concerned. But what people don't talk about, they always talk about the three branches of government, but they never talk about the fourth estate, right? And the fourth estate is the press, and it is a check and balance on the government, right? So if you research the term the fourth estate, what was the purpose of the fourth estate, you'll come to find that the purpose of the press was to be a check and balance on all other forms of government, right? To inform the population of, what the government is doing, um, what their actions are, how they're spending the money, all this other stuff, right? It's an external check and balance, and a lot of the founders thought that it was very needed. That was one of the most important uh, cornerstones of freedom was the free press, along with free speech. Um, so that's the part that these guys always miss. They don't understand the importance of the free press, right? Because again, most people have grown up with, CNN and Fox and ABC and CBS, and getting their version of the media, right? So let's go on.
It's there's no way that they can square that. Does that make sense?
That is really interesting. I'm glad we're having this conversation because I had no idea about this. Like,
Yeah.
that is really interesting.
And I'm sorry to have to subject you guys to this idiot frauditor troll. As we can see here, he's like, I had no clue about that. So dude's admitting on the internet for the rest of time that he had no clue that the judiciary was the final say on the law and the interpretation of the law. I mean, that's been since what, like 1803? Mayberry versus Madison? I mean, it's just ridiculous that, and then they'll try to judge us and tell us what the law is, and they don't have no clue. None of them have a clue. Even the guy down below, the murky picture, is supposed to be quote unquote a lawyer, and he came on Josh's idiot troll, channel to discuss case law that proves us wrong. So we're getting into all that, guys, but just be patient.
Yep. And another thing that I went back and forth with, and I know you've talked to him before, the Mile High Audits guy, and he was
Denver Metro.
No, not Denver Metro. His buddy, Mile High Audits.
Oh, okay.
Yeah. And I was sharing some of this with him. And he's like, I get that, but the First Amendment clearly says Congress shall pass no laws. I was right, Congress. That doesn't mean that the 10th Amendment and that a judge may not have some sort of policy that cannot enforce a no recording policy on the entire courthouse grounds. And there's some cases I can share with you that proves that policies are 100% enforceable. Because as you know,
see, and here he goes into the 10th Amendment. There's been a huge push on their side for them to question us and talk to us about the 10th Amendment, right? Because for some reason, and you'll hear it here, this idiot that says he's a lawyer will say it himself, but they suppose that the 10th Amendment grants rights to the states to make laws. And that's not what the 10th Amendment does at all, right? The 10th Amendment was written long after the states had their own constitutions and made their own laws, right? The Constitution doesn't give rights to the states, okay? It's the states that gave rights or powers to the federal government and the Constitution, not the other way around, right? So, and what the 10th Amendment says is that the powers that the states did not give the feds revert back to the states. Okay? Doesn't say that the feds grant any powers to the state. Doesn't say that the feds give any rights to the states to make their own laws. Right? The states always had that power. All right? But what's important to note is that just like what he said, Congress shall make no law, that abridges the First Amendment, that's the supremacy clause. If Congress can't do it, no state can do it. Right? That's the supremacy clause. The Constitution is the highest law of the land. Everything underneath of it has to be in harmony with it. Right? Has to be in harmony with it. So, all right, guys, let's continue on and hear some more stupidity.
These
I
guys
mean, we
love
see it all the time. We see it
Yeah.
all the time. We
and,
see
and
it
it's
all the time.
garbage. It's all garbage. It's 100% garbage. So having said that, and again, I just kind of wanted to preface that with, there's a lot more to the Constitution than just the First Amendment. There's a
Let me
reason.
ask you. They talk. I hear a lot that frauditors aren't considering the 10th Amendment in their speech. So, can you just like briefly explain how does the 10th Amendment
Yeah.
affect
So,
the frauditors?
honestly, to a degree, not it just depends. I mean, the thing that when it comes to constitutional law, it's extremely nuanced. It's extremely complex, and there's a reason why lawyers go to school for as long as they do. There's a reason why they charge as much as they do, and there's a reason. I mean,
They
it's
charge a lot.
It's extremely, extremely complicated. Very complicated. That's why, I mean, you've got people that specialize in First Amendment law. I mean, there's so many facets of the law that people specialize in, again, because it is so complicated. That's why, it's just amusing that these guys think they know more than this police officer that's been doing it for 25 years, or the judge that has 30 years of judiciary experience, or the lawyer, the prosecuting attorney that's been doing it for 15 years.
Folks, let's get something clear here. People, no matter how long they've been doing a job, people, no matter their education level, can still hold false beliefs. Right? So, just because somebody's been in a position for so odd many years doesn't mean that they don't have false beliefs even about their chosen career. Right? So, this appeal to authority fallacy that he's using here just doesn't fly, right? So you can be an idiot and still have worked in your field for 20 years, okay? Happens all the time.
It is hilarious.
Yeah, versus some snot-nosed kid that's been watching auditor videos for 2 weeks.
That's been watching Rogue Nation, right?
Yeah, I mean, it just makes zero
Shout out to Rogue Nation.
sense. I mean, it makes no sense at all.
So how does the 10th Amendment affect them?
I'm sorry. Yeah, back to your question. So, as the 10th Amendment in a nutshell basically says, the power is not vested or reserved for the federal government. Basically, go down to the state. For example, traffic laws. There are no federal traffic laws. It's all on the states. Voting laws. The states have their own voting laws. Most crimes, rape, or whatever it is, it's all reserved to the state. So that's basically what the 10th Amendment says: is that, hey, if it's not in the Constitution and if it's a power not reserved for the federal government, all right, states, you do your own thing. You do you. We do us. That's in a nutshell what the 10th Amendment says: is that all power is not reserved for the federal government through the Constitution. Go back to the states.
Sounds good. So how like which powers are not used by the federal government that affects the frauditors? Because I hear it mentioned a lot in my comment section, and I did Google it, but like you said, like it is complicated. I'm not a lawyer, and I wasn't exactly sure how it would affect them.
It does not prohibit a state or a local government, such and this, we're going to talk about this in a minute, a local government from having some sort of policy or some sort of ordinance that restricts certain rights. And
I see.
And we're going to go into an example.
That's incorrect. You can't have a policy or an ordinance that restricts people's rights. That's where civil rights lawsuits come from. right? You can't have a policy or an ordinance against asking for money, right? The Supreme Court said that that's a charitable, charitable speech. It's free speech to ask somebody for help. So, and it's covered under the First Amendment free speech. So, no city, no state can pass an ordinance saying you can't ask for money from somebody on the street, right? So we understand this, right? Everybody understands this. I know the folks on my side of the fence are a lot smarter than these guys, um, because we do our own research, right? We delve into it. We don't let what we think we know block what the truth may be, right? So, folks on my side, they understand, hey, maybe before I was taught something wrong, let me not believe everything I think is true and let me look at this objectively, right? And use common sense, right? So, the 10th Amendment has nothing to do with what we do. It doesn't mean that the states can prohibit filming in, public areas. It's not like the state can go, yeah, we can make our own law, so no filming in the park, no filming on your front lawn. Like, where do these people come from? They're idiots. They're straight idiots, right? We're going to get into more now, where they're talking about policies, right? And we'll debunk this as well. Let's go.
Here, and actually, that's a great segue into the first case that I want to share with you.
Okay, sounds good.
So the first one is, and again, I'm gonna. You can write this down, whatever, but I'm going to email all this to you, so you'll have a copy of it. But the first one is a case called Sheets versus City of Punta Gorda.
Yeah, Sheets versus Punta Gorda.
Yep, you might have heard of that one. Yep.
Yeah, I heard about it all the time. I know Mark Stout refers to it quite a bit.
Yeah.
It was independent journalist that was Andrew Sheets, right?
Yeah, I think he's in jail now.
Yeah. Okay. So what happened in that case?
All right. So what Mark Stout loves to say that this case proves every city hall is a non-public forum. Well, he's wrong. And I'll kind of explain how forums work in a minute. But basically, what the Sheets or what's behind it is auditors were going to the city of Punta Gorda, just raising havoc, causing a lot of disruptions.
Right.
And so the city ended up passing an ordinance which banned the non-consensual filming of city employees within city buildings. It was challenged, and the judge upheld it as constitutional. And it's actually case law. I mean, it is published case law in the Middle District of Florida. The reason why it was upheld is that the judge applied the forum test and decided that City Hall meets the standard of a limited public forum review, which
now the judge in this case has been rebuked over her understanding of constitutional issues in another case that made it up to the 11th Circuit. This case definitely is going to be challenged. I myself am going to be challenging it this year, be filing a suit against this ordinance and the ordinance for the county where Punta Gorda is in, which is Charlotte County. They have an ordinance that is similar to this, and for many different reasons, right? Now, what I wanted to get into is the forum doctrine, right? The forum doctrine does not apply to recording. It only applies to expressive acts. Okay? So, as Price v. Garland had pointed out, recording in and of itself is not an expressive act. Okay, it's part of an expressive act. Akin to a songwriter writing lyrics in a notebook is part of the expressive act. right? It's expressive when he takes those lyrics, puts them to a song, and goes out and plays them for an audience. That's the expressive acts, right? A band performing at a concert is an expressive act, but them practicing in their garage is not expressive because they're expressing it to no one, right? The same way if Stephen King is typing up a book, okay, and he's typing away at his house, that's not expressive. He's shown nobody that manuscript yet, right? And chances are, who knows, he may never show anybody that manuscript, right? So it's not expressive. When he takes that manuscript, gives it to his publisher, and they publish it, it then becomes expressive, right? Porter, when they're out there on the street asking people questions, interviewing them, that's not expressive, okay? When they broadcast that interview later that night, that is expressive, right? So it's a step in the expressive process, just like Price v. Garland put out, and which would pass the Spence test, which is the test to see if an act is expressive or not, right? So the Spence test states that you must be, expressing a message, right? And that people, when they look at you, or they see what you're doing, they must be able to decipher what that message is, right? So recording, standing there, quiet, or even, humming, or whatever you're doing, right? If you're not up there with your camera saying, I'm videoing for blah, 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 abortion or taxes, or whatever it is, if you're not exclaiming the reason why you're filming, nobody has a clue what you're filming for, right? So it's not expressive. All right, let's continue on.
Means that the restriction on filming, which is the ban on non-consensual filming. Now you can still film. You can still go in there and film. You just can't film employees without their consent. So
Gotcha.
again, they didn't ban it completely, just a restriction. It's very.
I'm glad he pointed that out, because most of the idiots on that side, they don't never point that out, right? They always say, oh, Sheets versus Punta Gorda, you can't record in city halls. It's a limited public forum. It's not what the case says at all. The judge was very clear in the fact that if he was in there recording just the walls and the floor and the ceiling, no one could stop him from doing that, right? That it was his right to do that. She said it in the case. It's his right to be in City Hall recording. The problem is the ordinance says you can't record people without their consent. Okay? And she thought that was a reasonable restriction. However, you don't need people's consent to record them in a place that has no expectation of privacy. This is basic stuff, right? And now when we say, well, this judge was wrong, this guy's like, oh, well, you don't support the Constitution? What does that have to do with the judge being wrong? Are the judges not able to be wrong? Are they infallible just because the Constitution gave them the job? Like, some of these people's thinking is seriously, seriously damaged.
Narrowly tailored. The reason why it passed is, I'm going to read it verbatim. Let me pull it up. Is the judge ruled that it is a reasonable restriction because videos of several city employees circulated on the internet, leading to death threats, suspicious packages in the mail, and so many threatening calls that the city had to shut down its phone lines.
Yeah, and that happens all the time. That's called call flooding.
Yeah,
Yep. Yeah,
but
Mark Manchon has been arrested for that a couple times. He's currently facing charges for that exact crime.
So auditors that sit there and say, it's just a camera, it's just a camera, I'm just standing there, I'm not doing anything. Well, this is proof that these guys can disrupt city business. And it's proof that auditors caused the residents of Punta Gorda, Florida, to have fewer First Amendment rights than they once did.
Yeah,
I mean,
it
this is
sure does.
yeah. I
It
mean,
sure
they
does.
auditors literally were the cause of people having their First Amendment right eroded. I mean, this is like grass is green, water is wet, the sky is blue.
Now, granted, it was the behavior of Ian and some other folks down in Punta Gorda that ended up getting the ordinance enacted. However, let's be clear in the fact that government restricts rights regardless. Okay? Think about the gun ban in Chicago. It wasn't Second Amendment activists that had the city council ban guns in Chicago for 30 years, right? Which was overturned again because it was unconstitutional, right? Because you can't make an ordinance that goes against our rights. So, the fact of Punta Gorda enacting this ordinance, and it was because of auditors, just like the one in Easley's, because of auditors exercising their rights, which is why we're challenging that now in court as well. But you know, it's ridiculous thinking that you need consent for people to record them when they're in an area that they're allowed to be in that's publicly accessible. You know, here in Florida and in the federal law, you could secretly record here in Punta Gorda City Hall. You could secretly record the employees. You could secretly record the citizens in these areas that you're allowed to be in where there's no expectation of privacy. So it boggles the mind to think in all these places I can record secretly and there's nothing, absolutely nothing they can do. And you can go there every day and record secretly and there's nothing they can do. But once you show them that you have a camera, now you're not allowed to do that. It's ridiculous how these people think. Let's keep going because there's a lot more to go here.
Auditors caused this.
Yeah,
Auditors
caused this. Yeah.
Yeah,
So
100%.
so because of the death threats and because of auditors call flooding, the judge said, hey, this is a reasonable restriction. And the other narrowly tailored element of the limited public forum standard is it must be viewpoint neutral. All that means is it applies to everyone, whether if you are a kindergartner going in there or CNN or an auditor, doesn't matter who you are, you cannot film city employees without their consent. It means it applies to everyone. So this is a great example of how the 10th Amendment gave the city the right to pass a very narrowly tailored law that restricts filming. Their rights aren't violated because, again, you still have your First Amendment right. You can still go in there and record. You can still go in there and interview people. You can do everything you want. You just can't film them without their consent.
Makes sense.
Yep.
That's fair enough. And let me ask you, so how what's your disagreement with Mark Stout's interpretation of this? That
what Mark forgets is that the public forum, let me pull it up real quick. Find these images.
Now here is something that he actually gets correct. And it blows the mind of every anti-auditor out there what this guy's fixing to say about the public forum. But yeah, again, let's be clear. The public forum does not regulate filming, right? It doesn't regulate it. It might live streaming. If you're live streaming, it might regulate that. But if you're static recording, the forum doctrine does not regulate whether you can record or not. All right? It's for expressive acts only. But listen to what he says about forums and if you can record in them or not.
Oops. There we go. All right. So when it comes to a public forum, when it comes to the forum doctrine, there's basically four types of forums. You got a traditional public forum, designated public forum, limited, non-public. The inside of a government building is yeah, unless it's an exception, it's going to be a limited or non-public forum.
Right.
All that means is that it's a standard that the government will use to test the restriction. It does not automatically mean that you cannot record in there. And that's where a lot of people get wrong. They'll say, hey, that's a non-public forum. It means you can't record. No, that is not. That just all that means is that it is a standard that the judiciary will use when testing the restriction. So the reason why Mark Stout.
Okay, so to break this down, so make sure everybody gets it. Okay, the forum doctrine is a test that's put in place by the court to test the restriction, right? So, one, there has to be a restriction, right? So if there's no restriction, then it doesn't matter what the forum is. Okay? It's important to note that. But again, it's also important to note, and again, this is when the forum doctrine is used, it's used to test restrictions on free speech, on expressive acts. So if you go back through history of the courts and you pull up every public forum doctrine case there is out there, what you find is that they're talking about speech. They're talking about protest, right? It doesn't matter what cases you're looking at, solicitation they're talking about, like in Kokenda, and the airport one, Hare Krishna, one where they declared that airports were non-public forums. All these cases deal with an expressive activity, solicitation, protest, like in Tinker with the armbands, with the sit-ins, speech has to do with speech. And you could tell that not only by the cases, but by the wording in the cases, right? It says, speech, expressive, there's never been a case, a public forum doctrine, landmark case, that has anything to do with filming. In fact, I believe there's only 2 cases that deal with the public forum doctrine and filming. One is Kushna, which was in a college auditorium during a class, during a lecture, right? So it was a place that wasn't open to the public generally. And the other one was at a press conference. I think it's Evers or Evans or Evers. And that case was a news agency didn't meet the qualifications that the government entity had put on what the qualifications needed in order to get into a press conference. It was a small affair. They only had so much room, and if you didn't meet these qualifications, you weren't allowed to attend the press conference, right? An invite only or whatever, and they didn't get an invite, yada yada. And they challenged it and said it violated their First Amendment right. And they said it didn't because it was a limited public forum, and basically they were right in the fact that this wasn't a place that was open to the public generally. So they had no right to be press conference, right? So like if I call up the Tampa Bay Buccaneers organization and say, hey, I'm Rogue Nation, I'm part of the media, I'd like to come in and get a free access to the game on Sunday and sit around and take some pictures and videotape it. There's qualifications they have to meet in order to get access to those events, right? And I don't qualify for it, and it's not a violation of my rights because I don't qualify for it. I could go get the qualifications if that's what I wanted to do. So it's important to remember this stuff.
What is wrong is that you're going to have different um, tests for different forms. So, example, the city of Punta Gorda City Hall, the judge ruled that was a reasonable restriction because they were getting death threats and call floods disrupting city business as a direct result of auditors. You take the city hall in the town next door, if they don't have auditors going in there and that are ultimately leading to death threats and call flooding, it's not going to be the same reasonableness. Does that make sense?
Yeah,
Because
I understand. I understand.
so
It
that's what
depends that the events that are being caused by the
exactly.
troublemakers.
It's going to depend on location by location. I've seen there is a case out of Georgia where the auditor they ended up settling, but he was filming at a jail or a prison, and the prison tried to claim that they were a non-public forum. The judge did the non-public forum analysis on it and said, yeah, you do have the right to restrict filming, but your restriction is too broad. It wasn't narrow enough. Like, the city of Punta Gorda, it's specific to non-consensual recording. You can still record, but you just cannot film somebody without their consent. Very narrowly tailored. So that's where it can get really, really complicated, where auditors will say, well, hell, I was at the such and such city hall. They let me film. Yeah. Just because it's a non-public forum doesn't mean that they're going to have the restriction or they're not. They just have the option of doing that. If there's not
It's their choice. Yeah,
yeah,
I understand. I understand.
yeah, exactly.
So,
So that's where
hey,
Mark's wrong, is because just because it was at Punta Gorda doesn't mean it's going to be the same elsewhere, because they may not have, like you said, they may not have the same situation.
but
the same
what you're
troublemaker.
saying is that if other city halls put restrictions similar to Punta Gorda, they could restrict filming.
Yeah, possibly. I mean, there's a lot that the government considers when determining whether or not if the restriction is reasonable and viewpoint neutral. They look at the purpose of the forum. They look at what it's traditionally been used for. They look at the size of it. I mean, there's a lot of different factors that they consider when determining whether or not if the restriction is constitutional or not. Again,
Sounds good.
So
let me ask you about another case. So, what other case did you want to talk about?
A lot of auditors love to say that, hey, it's publicly accessible, so that means I can automatically film. Bullshit. Nothing could be further from the truth. The first case, this is a Supreme Court case, United States versus Grace, and it says publicly owned or.
Now he's going to be citing U.S. versus Grace here, okay? Now, U.S. versus Grace, again, is another forum doctrine case, right? Let's listen to what he has to say here on the U.S. versus Grace.
Operated property does not become a public forum simply because members of the public are permitted to come and go at will.
Okay, United States versus Grace,
Yep,
1983, the Free
Yep.
Speech Center. All right.
Yep. And that basically, so they love to say if it's publicly accessible, they're allowed to film. That's nothing could be further from the truth.
That's absolutely 100% the truth, okay? And again, he's using, a public forum case, U.S. versus Grace. It's a federal law prohibiting picketing, okay, which is an expressive act. This is an expressive act that we're seeing here in this picture, right? They have a message. People viewing it can understand their message. It's an expressive act under the Spence test, okay? Two totally different things. All right, he's saying just because it's publicly accessible does not open it up as a public forum for expressive activities. And he's right. Just because you can go into City Hall does not mean that you can go in and picket at City Hall. Doesn't mean that you can go into City Hall and set up a booth and start soliciting funds. Doesn't mean that you can grab an amplified microphone and go into City Hall and start preaching. You can't. But can a preacher who's waiting in line to pay his utility bill, can he write part of his sermon in his notebook that he carries in his pocket? He absolutely can. Is that protected under the First Amendment? It is. Okay, the same way that a manuscript is protected under the First Amendment, even though, again, it's not expressive. It's a part of the expressive process, right? This is the nuances that they're not getting, right? It's a part of an expressive act. Okay, me reading something with my eyes is not expressive. Me reading something with my eyes and saying it out loud while I read it is expressive, right? Or me reading something, forming an opinion in my mind, and then expressing that opinion is all one expressive act, right? But me reading it is not expressive. So this is the nuance that people need to understand, because they're getting a lot of auditors on this public forum thing because we're not arguing what we need to be arguing. All right. And we definitely need to be arguing that, recording is a part of, a step in the expressive process, but in and of itself, it is not expressive. And while it is protected under the First Amendment, it's not protected under the public forum doctrine, right? And as Price v. Garland put, any restrictions, any blanket restrictions on filming public officials is not reasonable, right? So even if filming were under a reasonable, a non-public forum standard or a limited public forum standard, the restriction still has to be reasonable. And a restriction on filming your public officials in public is not a reasonable restriction. So, I mean, they lose on both ways, however they want to play it. But we have to put forth the right arguments, right? If we're not putting forth the right arguments and we're getting decided upon, like in Sheets v. Punta Gorda, they didn't put forth the right arguments and they lost, it doesn't mean that that can never be challenged. That doesn't mean that that's the law forever. And again, I'll be challenging Sheets versus Punta Gorda this year. You guys will be seeing that on my channel. So, all right, let's keep going with this fool.
Now this kid
I see it talks about sidewalks.
Yeah, so the sidewalk, it may mention the U.S. versus Coquinda case, which was they were out in the sidewalk. So even sidewalks could be a non-public forum as well. So just because it's a sidewalk does not mean you 100% have the right to film. If it's, for example, if it's a sidewalk that leads from at a jail and it leads from the employee parking to the employee entrance, chances are that is not a public forum, because the purpose of that sidewalk is to transport employees from their cars to their work. Again,
Gotcha.
It can be extremely complicated. Now, I think this kid lives in South Carolina or North Carolina.
Yeah. Well, the First Amendment Protection Agency.
Yeah, I think he's a Carolina kid, if I'm not
mistaken.
Versus Barber.
Okay.
Yep.
State versus Barber. Okay.
Yep, 2021.
It says 2023 here.
It's 281 North Carolina, Appellate 99.
Yeah, it says in the Court of Appeals of Ohio, 6th Appellate District, Lucas County.
It's the wrong case. This is a North Carolina case. Yeah.
Okay, State
versus Barber. Type this in: State versus Barber.
All right.
That a post office is out, poster 7 specifically saying poster 7 specifically prohibiting what is it, the right to oh shit, I just totally lost my train of thought.
Yeah, I
Uh,
have it right here.
yeah, where from the Kokinda case, where it ruled that a post office is a non-public forum, and the right to assemble.
Okay,
Uh,
so which part of it is it?
so if you go to, hang on, let me find it. I gotta go back. I just lost my. So the Kokinda case. This is to the point about sidewalks. The Kokinda, they ruled the postal sidewalk they ruled a lot of things, but in it said the postal sidewalk was constructed solely to assist postal patrons to negotiate the space between the parking lot and the front door of the post office, not to facilitate the daily commerce and life of the neighborhood or city. Very important, postal entryways may be open to the public, but the fact alone does not establish that such areas must be treated as public fora under the First Amendment.
Yeah,
So,
the frauditors love to cite this for some odd reason.
well, it proves them wrong. And if you read Poster 7, it specifically prohibits public assembly. And the right to assemble is one of the freedoms that we have in the First Amendment.
Exactly. So where does it show? Just for the viewers,
In Poster 7?
yeah, because I've seen it before,
Yeah,
but
can you pull it? Can you pull it up? I'm not even looking at the screen. Looking at something
yeah,
else.
yeah, it's right here.
Hang on, I got to go back to.
So there are specific restrictions, says
Yeah.
disturbances.
Hang on, it's right there under special restrictions, public assemble and public address, right there.
Okay.
Go back. Scroll back up.
Yeah, public assembly and public address right here.
Yeah,
Okay.
read that right there.
Yeah, so it says.
So let's read it right there. It says leafletting, distributing literature, picketing, and demonstrating by members of the public are prohibited in lobbies and other interior areas open to the public. Okay? All of those are expressive activities. All of them. Okay? It says public assembly and public address, except when conducted or sponsored by the Postal Service, are prohibited in lobbies and other interiors open to the public. Okay? One person is not a public assembly. Okay? When you're doing a public address, you're addressing a message to the public. And again, this is not something we're doing, right? We're not engaging in expressive activity. Even though we may talk while we're filming, unless we're saying what the filming is for, as far as like a viewpoint, this is a news report about, Republicans or abortion or taxes or whatever else, then we're not expressing what our message is for, right? And people that are watching, citizens, they don't understand the message that we're sending, right? That only comes later when we put the video out, right?
Leafleting, yeah, distributing literature, picketing, and demonstrating by members of the public are prohibited in lobbies and other interior areas open to the public. Public assembly and public address, except when conducted or sponsored by the Postal Service, are prohibited in lobbies and other interior areas open to the public. And that is part of the First Amendment, which is protesting. And it says right there they can't do it. So
there you go. Yep, there you go.
It's so easy to punch a hole in their like feeble little theories.
Yeah, it's nothing more than a script. That's all it is. So I'm going to just go over. I mean, there's a ton of them. I mean, I'm just going to email this to you, but I'll just read it real quick. Some of these are auditor specific, some aren't, but a lot of these will prove because they love to say policy is not law and it's not enforceable. But I'll just kind of start going down them. In Somberg versus Cooper, the Eastern District of Michigan denied a plaintiff's motion for summary judgment when the plaintiff argued he had a First Amendment right to record courtroom proceedings. The court held that courtrooms are non-public forums and declined to find there was a First Amendment right to record in the courtroom. And People versus Ackerman, the Michigan Court of Appeals upheld a restriction or a policy on photographing jurors after court proceedings as constitutional because it was a reasonable time, place, and manner restriction under the First Amendment. This is one of my favorites, Commonwealth versus Bradley. This is an auditor-specific case. The Superior Court of Pennsylvania evaluated a no filming policy that applied to the police department lobby. The court upheld the no filming policy as a reasonable time, place, and manner restriction based on the police department's privacy and security concerns. So this case right here, it was an auditor went into a lobby of a Pennsylvania police station, started filming, doing stuff that auditors love to do. He was told several times, hey, we have a policy. You cannot film in here. They had it posted. Hey, that's policy, not law, blah, blah, blah. And they warned him, look, you need to stop filming or leave. If not, you're going to be trespassed. He ultimately was arrested for trespassing. He was convicted, appealed, and this is the appeals court decision. Said that the policy is constitutional. He did not have a established right to film in the lobby of the police station.
That specifically was an auditor named Pissed Off Taxpayer, and he was convicted. And this is what I mean by saying we got to have the right arguments. Because if we don't have the right arguments, we will get convicted, right? So we got to have the right arguments. Because obviously this policy violates the First Amendment, right? If it's a generally open area, we should be allowed to film. But we want to be clear also in that there are policies that are legal that everybody has to abide by, right? No shirt, no shoes, no service per se. But these are policies that are usually backed up in some way by law. No smoking within 25 feet of door. And they don't violate rights is the other reason why a policy would be enforceable, right? So you can't have policies saying, no blacks allowed, no women allowed, nobody under 4 foot allowed. You can't have policies against that. So as long as the policies don't infringe upon our rights, then it's totally legal for them to have policies that we have to abide by. In the library, you can't, be yelling and screaming. So there are policies out there that we do have to abide by, but like the no filming policy in a generally accessible public area is definitely not one of them. But we have to make sure that when we fight these cases, we're fighting them with the right information, right? And using the right defense to fight these cases, because otherwise we end up losing. And then, guys like this try to make it into something that it's really not.
So that proves that
it's written right there, black on white. I mean,
yeah. Kerr versus City of Boulder. This is another auditor case.
Kerr versus Boulder.
City of Boulder, Colorado.
Okay, I see it right here.
Yeah. District Court of Colorado held that the exterior and curtilage of county jail property was not a traditional public forum, and that plaintiffs did not have a First Amendment right to film in those areas. These were two knuckleheads. They wore fucking ski masks, went to a fucking jail to start filming, and they were wondering why they got arrested. Yeah,
that sounds ridiculous.
Yeah.
Like if it was a movie, I wouldn't even believe it. But
I know, yeah. So they sued and lost.
Wow.
Another case, Kushner versus Buta, BUHTA, the District Court of Minnesota
versus BUHTA.
BUHTA. Yep. District Court of Minnesota upheld a restriction on filming during a presentation at the University of Minnesota Law School, holding that the auditorium where the presentation occurred was a limited public forum and that filming restriction was reasonable and viewpoint neutral. There's so many of these.
And that was reasonable there, again, because that's not an area that's open to the general public, right? That's a college lecture hall, and that he's actually at a lecture that's going on right now, right? So if I could just pop into a college lecture hall and film it and then upload it so you wouldn't have to pay the $35 to hear the professor's lecture, then I mean, you're talking total chaos, right? So at no point was filming allowed in this lecture hall. Um, and of course, there's many reasons for that: intellectual property rights. The professor, whatever he's discussing, maybe. Um, there's all kinds of things, right? You can't go into a lecture hall or a seminar or something where they're giving out information that they're charging for and record it, um, when there's a policy against recording it. So no issues there, right? There's but the judges are still using the public forum doctrine to try to regulate filming, right? And that's something we have to get them off of, right? And I was glad to see Price v. Garland tackled it last year, but more courts need to tackle it and understand it, because the logic is sound in the case. So if the logic's sound, it should be able to be applied equally everywhere. So that's what I'll be doing in my cases. And again, we gotta have those right cases to put in there. We gotta have the right understanding of why we're allowed to do this, why this doesn't affect us, why this does affect us, and everything such as that. But he's got a little more here too, guys, but I'm gonna let it go. I don't think there's much more of interest here that he talks about. So not sure, but yeah, this is Kushner. I'm not sure what this one is. But most of the cases that he give are, region specific, like the Commonwealth versus Bradley he was just going on about for pissed off taxpayer. That only applies in Pennsylvania. Sheets v. Punta Gorda only applies in the Middle District of Florida. These aren't precedents that apply nationwide. And again, that they never will be, because they're wrong in their application, which is what we're going to be doing. With Punta Gorda, we're going to be challenging that. So stay tuned, guys. Sorry this was so long one, but we need to start getting a better understanding of this, because people are losing in court. People are getting arrested and going to jail. I'll be doing a specifically post office oriented video coming up for the new folks coming into the movement that are going to these post offices. I see a lot of them getting trespassed. I see a lot of them even getting arrested, and we need to stop that, get a handle on it. So I'll be doing a post office specific video here shortly, with some downloads of some documents that every auditor should bring when they're doing a post office audit. All right. So thanks again for watching, guys. Leave me a comment. Tell me what you like, dislike. Tell me what your thinking is on some of these legal issues, and throw out some case law or something. Let's see what everybody's got to go.